Slaying Sunnah, Abu Ishaq al-Shatibi's concept of Bida in al-Iʻtiṣām. Thesis submitted to the University of McGill, Montreal, Canada, 1999. Asif Saifuddin Jahar. Chapter 1, from al-Muwafaqat to al-Iʻtiṣām. Between his al-Muwafaqat and Iʻtiṣām, al-Shatibi responds to and criticizes deviations from religious law in Muslim intellectual circles, basing his argumentation on the Sharia. His landmark work, al-Muwafaqat, focused on a legal discourse, demonstrating on the one hand the digression of jurists in applying the law too leniently, and on the other the undue difficulties created by Sufis. Elsewhere in this work, he provides a discussion of the way in which fatwas were used by his contemporaries to meet their own needs, desires, and interests, and not the requirements of the law. For al-Shatibi, the law applied for all mukallafin. A mukallaf is someone who is subject to law, so he's responsible for implementing the law, or responsible and legally bound by the law, and was of equal weight for men and women, whether dictated to by the Sunnah of the Prophet or the Quran. There should be no distinction between Muslims who are of sound mind, mukallaf. No person can be absolved of its ordinances, argues Shatibi. His intention seems to have been to correct what he saw as the Sufis' misconception of the ends, maqasid, of the law. He described the Sufis' attitude towards the question of paying the alms tax, zakah, as ambivalent. They insisted on the one hand that the refusal was in conformity with the Sufi school, while on the other hand it depended on the school of the petitioner. Sufis, As-Shatibi says, conceived of themselves as superior to ordinary folk, whereas by nature all sound people are subject to the laws of God without any distinction. Shatibi says that's because Sufis considered themselves distinct. They were allowed to do things not open to non-Sufis. When he comes to discuss whether the benefits of zuhd are recommended, mandub, Al-Shatibi divides it into three categories. The term was employed by Sufis in a more meticulous sense than by jurists. Though zuhd is lawful as a form of deep spiritual training, its excessive habitual performance could result in reprehensible or even prohibited mamnu' behavior. For instance, clothing and food can be abandoned for a given period of time, but to abandon them forever would be prohibited. Zuhd of the first category, Al-Shatibi says, applies to those ordinances which the law prescribes should be neglected. The second, favoured by most pious people, including the Prophet and his companions, consists of abandoning only things categorized as bad, under circumstances rendering them more beneficial than harmful. The third category is abandoning permissible things either intentionally or not. If the intention does not, it lies under forgetfulness, thus lawful. On the contrary, if the intention does on the ground of worldly matters, it is not counted as zuhd. If it is on religious matters, this can be counted as fadila, a goodness. Quoting al-Ghazali, who died in 505, commensurate with 1111, Shatibi opines that zuhd is the departure from the sheer desires to the better alternative. Sufis were generally considered more pious and more possessed of miraculous powers than ordinary beings. People in Andalusia often sought their help. Shatibi denounced this activity, arguing that the miraculous should only be sought in the Prophet and his Sunnah. Legitimate miracles, karama, he insists, do occur and can be accepted as long as they do not contradict the basis of the Sunnah of the Prophet. Nevertheless, the Sharia, he argues, is superior and should be used to refute both superstition and personal claims to elevated status. The Sharia for him was the only criterion for judging the validity or legality of all human actions, including the existence of miraculous saints. Obviously, Shatibi believed that the Sharia subordinates all Muslims to its guidelines, regardless of whether the person is a Sufi or not. Before elucidating the distortions which overtook the interpretation of the ends, maqasid of the law, Shatibi differentiates between ibadah and adah, worship and custom. The former for him is performed for the sake of submission, ta'abbud, without any question as to whether the pertinent act is reasonable or not. The latter, however, is subject to such questions and may be perceived through reason. Ibadah, therefore, is absolute and certain and needs neither addition nor subtraction. Though adah, custom, falls under the rubric of ibadah, it is generally subject to reason, maslaha, in its implementation. Having discussed the two categories of divine ordinance, ibadah and adah, Shatibi turns his attention to jurists whose treatment of the aforementioned topics may be deemed circuitous. From his perspective, the fellow jurisconsults were far too lenient in applying the law and too quick to pursue their own personal interests. Jurists, for instance, often supported their interpretation of law with legal stratagems, hiyal, singular, hila. Hiyal, Shatibi says, emanates from the exemption of a mukallaf from his or her obligation to make something lawful which is otherwise prohibited by law. Before Shatibi, Ibn al-Qayyim al-Jawziyya, who died 751, commensurate with 1350, elucidated the dangers of the stratagem hiyal, used as methods of issuing fatwas. For him, the use of a hila is determining the law violates the shari'. In determining the law violates the shari'ah's jurisdiction by blocking the means, sadd al-dhara'i', of averting danger. Though Shatibi agreed that stratagems provoked havoc, he did not reject the use of hiyal outright, but accepted it in cases where they conform to the law and its ends. An example of a lawful stratagem is the confession of one as being a kafir in the case of self-defense. Shatibi insists this aims at implementing benefits which are universally applicable. Resorting to unlawful stratagems or combining the doctrines of more than one school in an arbitrary manner defeats this purpose and wreaks havoc on the universal provision of the law. Recognizing as he did these shortcomings, Shatibi not only tried to revive the sound traditions, as-Sunnah al-Hasana, by resorting to the Quran and the Sunnah, but he also criticized the jurists and Sufis of his time for having deviated from the true Shari'ah. This was substantiated by Wa'il Halaq, whose study of Shatibi's legal theory has led him to conclude that Shatibi's goal was to establish a middle course between considerations of personal benefit on the one hand and undue difficulties caused by its absence on the other. The former position was taken by the jurists, the latter by Sufis. Stay tuned for many more parts.